Доброго ранку. Ми з України. Рада вітати вас на
Good morning. We are from Ukraine. I'm happy to see you at the 5th Scientific and Practical Conference, Tax Disputes in Administrative Proceedings in Ukraine, which is held in the framework of the Days of Administrative Justice. This year, we are celebrating the 20th anniversary of the setup of administrative courts. Despite everything which happens in our country, this morning is indeed good, and I'm very happy to see all the participants online sitting together to discuss the issues and challenges of administrative and tax justice. I'm now very pleased to give floor to Vsevolod Knyazev, Doctor of Law, President of the Supreme Court of Ukraine. Thank you, Raisa, dear participants, dear colleagues. Thank you. I'm very happy to see you all. I'm very grateful to you for having joined our conference in these challenging times. Despite the fact that the main attention of Ukrainian society is now directed to war, the disputes remain very topical because it's the taxation policy of the state, which is of direct relation with economic politics and economic well-being of the country. On the other hand, we cannot but mention that taxes and economic and business activities have direct impact on the success of military actions of our country. It is how we finance our army. So the topics that we are going to discuss today are indeed very important. Today, political authorities in Ukraine are discussing further actions to stimulate taxation system and improve taxation system in order to be able to respond to emerging challenges relating to war. This is what we're going to discuss today. No doubt, we're also going to touch upon the topic of the European integration. We're going to talk about the necessary change in tax administration, which is one of key prerequisites for Ukraine's joining the European Union in the nearest future. We're going to touch upon existing national and international jurisprudence. We're going to discuss the peculiarities of appeals and cassation appeals submitted to the courts during martial law. We cannot but mention that despite the fact that active hostilities are taking place in different parts of our country, the number of above-mentioned appeals and cassation appeals remain quite high. We're going through a very complicated period in the history of our country. The war affects lives of Ukrainian citizens, but also the operation of Ukrainian businesses. And in this connection, even more tax disputes arise, relating in particular with tax administration, tax assessment, and tax enforcement. The legislators, together with other stakeholders, are trying to be flexible and to adopt necessary amendments in order to allow the Ukraine's taxation system survive and remain effective and efficient as it requires wartime and martial law. I guess that the ultimate goal of the legislator as well of the Supreme Court and other stakeholders in particular by organizing and conducting such events as ours is to reach legal certainty and uniformity of legal practice. I wish you us all good luck and thank you. Mr. Knyazov, thank you very much. It is indeed very complicated to imagine Ukraine's administrative justice without Mikhailo Smokovich, who has dedicated 20 years of his life to the development of administration justice in Ukraine. I'm very pleased to give floor to Mr. Smokovich. Thank you, dear judges, dear foreign guests, dear representatives of international organizations, academia, dear participants of the fifth conference on tax and administrative law. Dear friends, I congratulate you on the occasion of the opening of the fifth scientific and practical conference on tax and administrative law, theoretical and practical issues. I'm very pleased to state that holding such conferences has become a good and long time tradition in the Cassation Administrative Court of Ukraine under the Supreme Court. We hold such conferences on annual basis. And this year we're celebrating a very small but still anniversary, fifth anniversary. I'm very proud that 5 years ago, the Cassation Administrative Court of Ukraine launched this good tradition to conduct such conferences annually. The first one took place 5 years ago on the 5th and 6th of July. I'm also very pleased to announce that our friends from the German Foundation are also celebrating a bigger anniversary today, the 30th anniversary. We congratulate you. We wish you all good luck. We wish you all success. I am very pleased to underline that the setup of administrative justice in Ukraine has happened in close cooperation with our German friends, including from the land Rhine-Pfalz. We are grateful for being by our side, and we are grateful to you for sharing your knowledge and experience with us for more than 20 years already. Our today's conference is dedicated to the resolution of tax disputes. The participants are invited to take part in the conference online rather than offline, even though initially we thought to hold the event in the suburbs of Kiev in the State Tax University located in a beautiful town of Irpin. Unfortunately, the war made us change our plans. The town of Irpin got under furious attack of Russian army. And unfortunately, we cannot hold any event in the town of Irpin these days, but the town of Irpin is rather attended by international leaders in order to see with their own eyes all damages and destructions inflicted by the Russian army as a result of their aggression. Now, I cannot but mention the Kharkiv Legal Academy named after Yaroslav Mudry. I cannot but admire courage and dedication of the faculty of this university, as the city of Kharkiv is under constant and daily attack of Russian troops. And despite this, it continues operating and it continues functioning. Many people died as a result of Russian aggression. So please, a minute of silence for them.
Дякую вам. Ми твердо знаємо, що
Україна бо за нами правда і з нами віра. We strongly believe that Ukraine will win. We are determined to do so. Let us continue our work now. The tax relations are multifaceted, and thus the object of tax dispute is multifaceted. The object of tax dispute may concern not only internal national issues, but also imply the international component. Solving disputes, arising taxation disputes, is impossible without having constant dialogue among all the stakeholders, including tax administrations and administration authorities, tax enforcement authorities, and taxpayers. I'm very grateful to Всеволод Князев, President of the Supreme Court, justices of the Supreme Court of Ukraine, judges of courts of all instances, and to all those who have joined our today's conference for your readiness to talk to each other, to discuss the most pressing and important issues. And I'm, of course, very grateful to our external partners, State Law Academy of Ukraine, Kharkiv Legal Academy named after Yaroslav Mudry, IDLO, Office of the Council of Europe in Ukraine, Pravo Justice Project in Ukraine, and to all those who have contributed to the organization and conducting of our today's and tomorrow's events. I'm sure that we will have a wonderful opportunity to exchange opinions on various theoretical and practical questions, and would suggest some solutions to the existing challenges relating to administration of justice in tax-related disputes. I wish us all peace, career success, and all the best. Thank you, and glory to Ukraine. Glory to our heroes. Thank you, Mr. Smokovich. Indeed, rebuilding Ukraine and effective tax policy development is impossible without support of our international friend. And I'm now very pleased to give floor to Dr. Stefan Hellhofster, Director of the German Foundation for International Legal Cooperation.
Thank you very much, Mrs. Hanova. Dear Mr. President Knyazyev, dear Mr. President Smakovich, dear Mr. Chairman, members of Parliament, Excellencies, dear colleagues, and dear friends. First of all, I would like to thank you very much for being invited to the 5th Conference on Administrative Justice in Ukraine, which already is a small jubilee dedicated to tax law, this time and taking place on the eve of the adoption of the Ukrainian law on administrative jurisdiction. We are meeting today in most difficult times, difficult for Ukraine and for all Ukrainian people, difficult for all of us. As I said already last week at the conference together with the Constitutional Court, the IRZ is outraged by the unilateral aggression of Russia in Ukraine and condemns this war of aggression and cruelty. Our full solidarity is with Ukraine, with all our partners in Ukraine, and with all people of Ukraine. These times are a test for the principles of democracy and for the rule of law in Europe. The IRZ, working on behalf of the German Foundation, of the German government, and especially of the Federal Ministry of Justice, will continue its close and intense cooperation with the Ukrainian partners, and especially with the administrative courts and the administrative judges in order to strengthen the rule of law and now even more the EU harmonization process. I am convinced that Ukraine will continue its path of legal and judicial reforms, and I congratulate Ukraine for receiving the EU member candidate status. Now, necessary conditions have to be fulfilled. There's quite a bunch of homework to do before starting with the negotiations. The success of the European integration depends on a sustainable and on all sides accepted process, to which also the administrative courts, as the so-called younger sister of the constitutional jurisdiction, can make a decisive contribution, provided that they are not part of political interests. Independence of the judiciary is a pivot point to all reform packages. Without true and genuine independence, the rule of law will be malfunctioning. Law and justice are upheld by an independent judiciary, and that is one of the main goals of the European Union. And this must be particularly true for the administrative jurisdiction, as the administrative jurisdiction, amongst others, has to protect the rights of citizens against the state. The state sits in the driver's seat, so to say, and the administrative courts must provide a balance between state and citizens. Society's confidence and trust in the judicial system and in the administrative courts grow on the basis of their own decisions. In some cases, administrative courts are even factors in the political processes. And the responsibility of the courts and the judges in these cases are even higher. It's a responsibility for the reputation of the stand of the rule of law in your country. And as I said already, one of the criteria for EU full membership. You all might know that we have a long-standing cooperation with Ukraine in the field of administrative jurisdiction. On the German side, especially with the administrative courts, as Mr. Smokovich said already, of the land Rhineland-Palatia. Therefore, I'm honored and glad to welcome Professor Brocker, President of the Constitutional Court and of the Higher Administrative Court in Rhineland-Palatia, who does not give a lecture today, but who wants to pay his respect to the Ukrainian colleagues with his attendance. Let me also welcome the two judges of the Federal Fiscal Court, our so-called Bundesfinanzhof, responsible and last instance for disputes in the field of tax and customs law, except questions of related criminal proceedings. A warm welcome from our side to Judge Hübner and to Judge Stutzmann, and thank you for participating. These difficult times show us clearly how important our common principles of human rights and rule of law are, how important a stable justice system is. These principles are prerequisites for national and international stability. Thank you as well to Mrs. Huber and to Mrs. Pilipets organizing today's conference. And this is in these difficult times really hard and good job you did. We all would rather be with you in Kiev now, and I'm convinced that next time we all meet in Kiev again. All the best to Ukraine. Thank you for your attention, and I wish all of us a fruitful discussion.
Дякуємо вам. Дякуємо. Ми дуже хвилювалися, чи зможе приєднатися до
We
нас
were very much
наступний
our next participant
технічна
us
така можливість у нас виникла.
this technical.
Не можна уявити податкову сферу
We can
виваженою,
imagine
збалансованою
this
та на
here
результат орієнтованої правової політики.
in a balanced and
Верховної Ради в цьому механізмі надважливо.
better role of the parliament is more than
Данила Олександровича Гетманцева, голову
the
Комітету Верховної Ради України з питань фінансів, податкової та митної політики,
on the
професора
customs
кафедри фінансового права юридичного
professor
факультету
of
Київського національного
the
університету імені Тараса Шевченка, доктор
Shevchenko
юридичних
National
наук, професор.
University
Прошу.
abilities, and the floor is yours. Thank you so much for having me here and such an event that's very important one today. Federal administrative justice, in my opinion, is not the pillars in justice state of putting parties in society are found, and it's important this balance
йшов на користь
way
розвитку
so that it benefits country as a whole.
От сьогодні у ці дні проходить
These days we have
Луганська
conference
майбутнього України щодо
in
відновлення
Ghana
України від наслідків
for Ukraine about recovery after the war, and
Ми будемо говорити про
here
те, що основою
of the fact that basics,
нульовим рівнем побудови
the
майбутньої
ground
України
zero,
є
the building of
принцип верховенства права, відмова від
principle of the rule of law
залишків клановості
is
та
getting
олігархічної
rid
системи, яка у нас була
of
успадкована ще з часів СРСР і
lands and
зміцнена протягом 30 років незалежності,
bad legacy.
і побудова нашого
We are to
суспільства
build
на
our
засадах
society on the
верховенства
basis
права, поваги до закону
of respect,
і нульової толерантності до
zero
будь-яких
policy,
корупційних проявів.
manifestation corruption.
Але, ну, насправді
Yet, in
корупційні
fact,
прояви, вони
manifestations of corruption
є дещо ширшими, ніж
are a little bit
те, що
wider
під цим
than
розуміється в
what is
законі.
understood.
На мою думку, корупція, вона
In my opinion,
є, на жаль, дорогою
unfortunately,
з
it's
двома смугами
a two-way
зустрічними.
street,
І якщо б в суспільстві
and
ця корупція не
if
толерувалася у вигляді
didn't tolerate corruption,
різних проявів, в тому числі ухилення від оподаткування, в тому числі і в вигляді порушення тих норм, які встановлені законом, неповаги до закону.
established by the lawyers, to
Якщо б вона не толерувалася
the
суспільством, то,
society
напевно, рівень би корупції в
tolerate
державі був набагато менший.
it wouldn't
Це дорога з двома
there.
смугами, яку
That's
ми
why
повинні пройти з
open
суспільством,
street
державою, суспільство повинні пройти разом.
come together.
І в цьому
And
контексті
in this regard,
дуже важливим є
it is
судочинство саме в
important
фінансовій
to
сфері,
have
адміністративне судочинство в фінансовій сфері,
just
бо це
here
є
because
однією
this
з
is one
найважливіших
the
сфер
most
життєдіяльності
important
суспільства, навіть
area in
якщо
human life, even if
про фінанси не говориться,
the finance
все одно мова йде про фінанси.
does still
І
about
в будь-яких напрямах діяльності. Щодо
all
роботи Верховної Ради, то нами зроблено дуже
about
багато
elementary
для того, аби вдосконалити нормативне регулювання податкових
the
відносин,
training
фінансових відносин і наближення
and
нашого
estimating
законодавства до норм європейського співтовариства.
our
Власне,
rules to European
інтеграція в ЄС це також є
the EU is
головною темою,
also
головним
one
напрямом діяльності держави сьогодні. І
areas of
тому ми повинні виходити з того, що
we have to
це питання
dedicate
не вибору
on
нашої держави, це питання виживання. І тому
choice to matter
всі наші
right.
зусилля ми сьогодні спрямуємо на те,
Our
аби імплементувати якомога
to be
швидше
direct
законодавство ЄС, законодавство
implemented
України. На сьогодні
legislation
ми вже
Ukrainian
імплементували кроки БЕПС,
basic
більшість кроків БЕПС наше
most
законодавство. Ми вже
steps
імплементували 112 директиву в частині оподаткування електронних сервісів.
and
Ми зробили багато на шляху до
the
впровадження
way
NCTS в митних
having
в митних відносини
customs
з режиму вільного транзиту відповідно і
on
інших
and
прийнятних європейських норм
accept
до митного
the rules
законодавства, так
to
само
the
як і
legislation as
аналогічних норм до
as
законодавства податкового.
rules
Ми зробили досить багато
we
в
have done
сфері
quite a lot in the
інтеграції,
field
імплементації до вітчизняного законодавства
to
директив ЄС
legislate
у
direct
фінансових відносин, може напряму і не пов'язаних з податками,
maybe
але так чи інакше тих, що стосуються і протидії відмиванню брудних
it was
коштів, і стосовно
and
діяльності банківської системи в
party
цілому. Дуже
is such
важливо
important
розуміти те, що у податкових відносинах
that in tax
нам
relations
залишилося більше попереду,
we
ніж ми зробили.
a lot of
Перед
us
нами ще 22
we
директиви ЄС, які
to
ми повинні повністю або частково імплементувати для вступу.
actually implement
Президент і суспільство ставить перед нами досить чітку задачу
president
зробити
and
якомога швидше і
this
якомога
as a priority
в більш прийнятному для суспільства
kept in a more acceptable
стані з перехідними
side
відповідними положеннями, але
with respect to
це є необхідним для
that
інтеграції нас в
for us to
європейське співтовариство. З
with
огляду на це дуже важливою є правозастосовча
this
практика, яка, я абсолютно
before
розумію,
very
формується з нічого, формується
we
судами з
that
розгляду абсолютно нових справ,
consider
судді раніше не стикалися, але
the
в цьому
jurisprudence
контексті важливий і
this.
наш сьогоднішній захід, і важлива позиція Верховного суду,
and that's why it's
який повинен,
have
мені здається, дуже своєчасно і чітко
due
звертати
manner
увагу на ті прецедентні певні рішення, нові категорії спорів, які можуть з'являтися і зараз, і в майбутньому з'являться, аби
and in the
давати,
you know
можливо, виносити рішення у зразкових справах або
give
давати іншим
decisions
чином
either
свою
in
позицію місцевим судам, аби
simple cases that
правозастосовча
we use
практика
as
одразу
simple
сформувалася правильно, і нам не потрібно було її
so that
потім
we
ламати чи
very
змінювати,
so
щоб
it's not
породжувало б правову
break
невизначеність. Тому я
later
хочу побажати
uncertainty
успіху в сьогоднішній
all
конференції. Хочу
things today
відзначити дійсно складні часи, складні для всіх, але ми
indeed
обов'язково вистоїмо, обов'язково переможемо, обов'язково у нас
will
буде мир. Всім
win.
миру і
Wish you all
здоров'я. Дякую.
and please stay healthy. Thank you.
Дякую вам.
Thank you.
Україна неодноразово показувала свою проєвропейську
Here
позицію,
there
а
is
зараз
stage
ще
established
обороняється, тим самим
its
захищаючи усі
pro-European
від
position.
збройної агресії з боку Російської Федерації. Ми
It's
цінуємо допомогу Європи в цій
we
боротьбі
value
та віримо в наше спільне мирне
Europe's
майбутнє.
help.
Рада запрошую до вітального слова
Now I
Стефана
give
Сорова, голову Офісу Ради Європи, представника Генерального секретаря Ради Європи з питань координації
and
програм співробітництва Ради Європи. Прошу.
please, the floor is yours.
Thank you. Can you hear me? My translation is very bad. I would like to say my connection is very bad, but I hope you can hear me. Can you hear me?
Yes, I can hear you well.
Okay, because good. Thank you. The floor is the connection is very bad. So thank you very much, distinguished participant, ladies and gentlemen. I take this opportunity to express the admiration to the Ukrainian authorities, judiciary, lawyers, academics, to all who continue their operation despite the extremely difficult situations caused by the military aggression against Ukraine by Russia. Today is day 131 of the aggression. First of all, it's my pleasure to welcome you from Kiev. On June 15th, this year, the Council of Europe's office in Ukraine reopened. It is the first time that the Council of Europe reopens an office that has been closed, especially under the difficult security conditions. As the Secretary General, Maria Pejcinovic-Buric said, this is a dark hour for Europe and everything it stands for. The fact that the Council is present in Ukraine and implementing projects is very important for us, and we believe our Ukrainian partners, and a very visible way for us to show that we stand by Ukraine. The solidarity of the Council of Europe with the Ukrainian people includes actions within the mandate of the organization in assisting the Ukrainian authorities with their immediate needs to ensure human rights and rule of law in the war-torn Ukraine. The organization is now supporting Ukraine through the adjusted Council of Europe Action Plan for Ukraine 2018-2022, adopted by the Committee of Ministers and by ministers in Turin at the ministerial meeting of the Council of Europe 20th of May this year. It is focusing on key areas of concern. Among them is a support to the authorities to address immediate consequences of Russia's attack on human rights and displacement. In particular, facilitation of access to needs assessments and protection services for IDPs, including relevant digital solutions. Support to legal professionals assisting displaced persons. Support to Ukrainian criminal justice stakeholders in documentation and investigation of the gross human rights violation in the context of the military aggression. Protection of the rights of children affected by armed conflict, other vulnerable groups, and prevention from discrimination. Combating violence against women in Ukraine and in displacement. And of course, support to the judiciary in time of war. Delivery of justice in the time of war in Ukraine is constrained by several factors. One of the most important is the introduction of martial law on 24th of February 2022. It assumes a temporary suspension or limitation of the rights and freedoms defined in the Constitution of Ukraine. You will address this point within one of the panels today. According to the information from the Supreme Court, at the present moment, 5 court buildings in Ukraine are fully destroyed. 67 court buildings are destroyed partially, while many court buildings remain on the occupied territories. The territorial jurisdictions of these courts were transferred and judges, where it was possible, relocated. Even in functioning courts, the delivery of justice is complicated by the air raid alarms. Nevertheless, you continue to exercise justice. And this is crucial, since we all know justice delayed is justice denied. The Council of Europe, through our cooperation projects in Ukraine, offers expert advice as to how to organize the delivery of justice in line with the European standards under these circumstances. Also, the Council of Europe supports the training and awareness-raising activities for judges concerning the international humanitarian law, human rights protections of IDPs and war-affected people, including compensation for pecuniary and non-pecuniary damage caused by military aggression. In particular, the Council of Europe, in cooperation with the National School of Judges of Ukraine, are developing a new course on the judicial protection of IDPs and war-affected people for judges in Ukraine, and will hold a series of thematic workshops on the same topic in August, September of this year. The specialized course and the workshops will contribute to the advancements of the National Court's case law on the humanitarian right protection of IDPs and the war-affected people in Ukraine, in line with Council of Europe standards. Coming closer to the main topic of the present conference, we have asked the Council of Europe expert to draft a brief paper on the state of the tax benefits and state aid for the areas affected by war in Croatia. It reflects relevant experience of the Balkans that also severely suffered from war. In particular, a major incentive of the Croatian state was to stimulate the return and subsistence of the population in the areas directly affected by the war. Therefore, the settlement was encouraged by allocation of houses and apartments under certain conditions, which could become private property after 10 years of use. Also, the tax and customs benefits were introduced. For example, the taxpayers of the tax on profit were benefited with 20%, the first group of special care area, or 10%, the second group of special care area, of protective interest rate under defined conditions. The taxation on income was benefited to all who had residence in the special care areas by increasing the respective non-taxed limit. This implied deductions for children and other supported members of the family. Third, the benefits related to taxation of property. All legal transactions related to property in the special care areas were not taxed if the parties had the residence in those areas or would reside in those areas. Fourth, the benefits related to taxation of inheritance and gifts. From taxation were exempted physical persons who inherited the real estate in the areas of special care. And fifth, there were custom benefits, exempted the application of the custom law in the case if persons, both natural and legal, with residence or business seat at the special care areas made import, entry, or receipt of the equipment which would be used for the reconstruction and development of the activities on the special care areas. This is, of course, about possible future actions, but building solutions is the first step towards future recovery of Ukraine, and we will be glad to share this brief but comprehensive analysis with the stakeholders concerned. I would also like to remind everyone that preparing for the future is, of course, also very important. And as you know, many leaders of countries supporting Ukraine and the Ukrainian government is gathering today in Lugano, Switzerland, in order to discuss how best to organize the recovery and reconstruction of Ukraine. So in this regard, some of these experiences are, of course, also of relevance. With that, I will end my opening remarks, and let me all wish you a fruitful conference with in-depth representation, and let me reiterate that the Council of Europe stands with Ukraine. Of course, a special greeting from me to friends I haven't seen for a long time physically, but now see again here on the screen is of course coming from my heart. And of course also special greetings to all colleagues from Zaporizhia, from Kharkiv, from Odessa, from all the frontline towns and cities that suffer bombardments every day. Nonetheless, we are working and in that way also helping Ukraine. Thank you very much.
Дякуємо вам. Проектом ЄС «Право Justice»
Thank you very much. The project Pravo Justice in Ukraine has been contributing to the implementation and development of justice and rule of law in Ukraine in various areas. I'm now very pleased to give floor to Oksana Tsibrivska, Deputy Team Lead of the EU project Pravo Justice. Thank you, Raisa. Dear participants, dear friends, thank you for having me here. It's a great pleasure to participate in this event, especially considering that this conference is the fifth one. So indeed, it is a small anniversary. It is a good, long-standing tradition to sit together in the framework of days of administrative justice in Ukraine. It is indeed very important to make sure that Ukraine remains on the first pages within the international discussions and of international discourses, not only in the context of war, but also in the context of positive achievements and success stories. The war affected various aspects of Ukraine's life, but the judicial system showed its best as it continued operating, it continued being there for the interests of citizens and public authorities. In the meantime, from the very first day of war, Ukraine has been responding very successfully to all challenges which arose in connection with war. On the 14th of March 2022, President Zelensky initiated amendments to the existing legislation aimed at the adoption of the country's economic system to wartime. Another big achievement that should be articulated is the signing off by the President of Ukraine of the law on administrative procedure. This is a step which brought us closer to the European family of countries with long-term administrative tradition. This is a revolutionary law for Ukraine's legal system, as for the first time ever in Ukraine's legal history, the definition of discretionary powers was given alongside definition of many other terms which existed in other countries in a clearly defined manner for many years. So again, the adoption of the law on administrative procedure has been a big step forward, and the next step, the follow-up step, should be training of Ukrainian judges in particular on the application of judicial discretion in order to make sure that the newly adopted law is applied in full and uniformly by all judges across the country. Our project has been engaged with the judicial discretion issue for several years. Back in 2018, we have started holding first events dedicated to judicial discretion, to discretion of administrative authorities. We have organized a series of events involving international trainers. The events were dedicated to the explanation of the most important theoretical and practical issues of use of discretion by judges and by administrative authorities. So again, I'm very pleased that we are moving forward, that Ukraine's legal system is moving forward, and I'm pretty sure that the discussion we're going to have today will bring us even more answers and clarity. Thank you. Thank you, Oksana. Now the floor goes to Tatiana Kirilenko, acting chairman of the State Tax Service of Ukraine. The State Tax Service in any country has a variety of powers and is one of the most important players among public authorities, especially when it comes to wartime. Thank you very much, dear friends, dear participants. Thank you for having me here. I'm very grateful on behalf of the State Tax Service of Ukraine for having me here. Thank you for giving us this platform for discussion. We understand our responsibility and the importance of our engagement in political and legal processes taking place in the country in these challenging times. We appreciate very much your openness, and again, I'm very grateful for having us at the event. I'm sure that we will make our contribution to today's discussion. As you may know, in the framework of the tax reform launched by the President of Ukraine, the State Tax Service of Ukraine has much work to do. Alongside other public authorities, the State Tax Service has been operating in a very specific environment, starting from the 24th of February 2022. However, we were there, we were in place, we continued our operation, and now the main focus of one of the main focuses of our efforts is applied to restore proper functioning of the state tax service departments in certain regions of our country which are close to active hostilities.
Їх робота також не обмежена, в тому числі по супроводженню судових справ. Там йдуть активні бойові дії. І тому я хочу сьогодні подякувати всім представникам судової системи за вашу роботу в таких складних умовах, представникам тих регіонів. І те, що сьогодні ми тісно співпрацюємо,
we cooperate together to have fun. I hope that you will understand me and that even later it will be taken into account. This circumstances that we have and now how to work further, how to have it postponed. That's why I want to say that each of us has his own
які будуть виникати під час розгляду судами податкових спорів. І враховуючи сьогоднішню тему, я думаю, що ми зможемо знайти за час нашого заходу відповіді на ті питання, які сьогодні дуже гостро постають, і те, що нам необхідно буде обговорити. І сподіваюся, що всі отримають задоволення, всі отримують позитивний досвід. Всім бажаю гарного.
I hope that our today's discussion will be successful and fruitful. Glory to Ukraine, and once again, thank you very much. Thank you, Tatiana. Effective tax enforcement, both are needed. Practical skills and theoretical knowledge. I invite to take floor Anatoly Getman, Rector of the Yaroslav Mudry National Law University, Academician of the National Academy of Legal Sciences of Ukraine, Professor. Thank you, esteemed Raisa, dear participants to the conference. I welcome you on behalf of the huge faculty of the National Law University, Yaroslav Mudry. I wish us all the soonest victory in this unprecedented war waged by the Russian Federation. And I wish we could sit together around the table, in person, offline, to tell to each other everything we would want to share with each other. So the tax administration, tax enforcement is an important part of administrative justice and is a very important topic for discussion among practitioners and academia. I represent here the academic community, and the number of researchers in the area of tax law who are PhD in law, who are doctors in law, prove that this area is very rich, and there is much things to be explored and to be researched. The academic community often organizes various events, conferences, workshops, and other events aimed at discussion of various issues and peculiarity of the tax legislation. Such events are, of course, attended by the practitioners because it's the interaction and dialogue between theory and practice that allow finding effective solutions for various problematic issues which arise in the area. Speaking of administrative jurisdiction and administrative courts, these courts are supposed to ensure, in the first place, proper balance between the interests of the state and individuals. This function becomes even more important under martial law. The administrative jurisdiction is a guard of interests of individuals, especially under martial law. I would say that considering the increasing number of claims relating to unprecedented damages inflicted by the Russian aggression, the administrative courts become a shield protecting public and personal interests of Ukrainian individuals, legal entities, and public authorities. So thank you for your endeavor, and I wish us all good luck. Thank you, Mr. Gateman. Ensuring proper interconnection between theory and practice is one of the prerequisites for success. I'm now very happy to give floor to Alexander Petrician, President of the National Academy of Legal Sciences of Ukraine, academician of the National Academy of Legal Sciences of Ukraine, professor.
Шановний пане голово Верховного суду, шановний пане голово Касаційного суду,
esteemed President of the Supreme Court, esteemed President of the Cassation Administrative Court of Ukraine, dear friends, dear participants, dear colleagues, on behalf of the Presidium of the National Academy of Sciences of Ukraine, I would want to congratulate all of us on the occasion of the 5th anniversary of the Administrative Law Conference. This conference has indeed become a good tradition, bringing together experts and specialists from various countries and from all corners of our country, of Ukraine. It has been mentioned today that administrative jurisdiction was established in Ukraine 20 years ago, and I would want to say a few words relating to this. The path of administrative jurisdiction in Ukraine was not easy. There were even meticulations about whether the administrative jurisdiction is needed at all. I can remember various personalities, politicians, academia, casting doubt on whether administrative jurisdiction should continue existing. And I can remember those who were protecting the idea of administrative jurisdiction and explaining that having administrative jurisdiction as part of judicial power is one of key features of modern judiciary. We were fighting for administrative jurisdiction, and I would say that we won. I cannot but mention here Mr. Mikhailo Smakovich, Judge Mikhailo Smakovich, who was fighting for administrative jurisdiction in Ukraine more than whoever. Ukraine is becoming a candidate to the EU, makes the necessity to address the most pressing issues of administrative jurisdiction and of development of administrative jurisdiction even higher. The Legal Sciences Academy has long-term relations of cooperation and partnership with the Cassation Administrative Court of Ukraine. There are multiple areas of cooperation between our two institutions. We cover various issues, both theoretical and practical, in the framework of our cooperation. The Cassation Administrative Court justices are our dear friends, partners, and colleagues, and we value a lot our relations of friendship and cooperation. I wish to all the participants all good luck, the soonest victory of Ukraine in this war, and I hope to see all of you next year in person, offline, so that we could calmly and peacefully sit around the table and discuss the most important and the most pressing issues related to administrative jurisdiction. Thank you. Thank you, Mr. Petrician. I am grateful to all those who delivered welcome speeches.